Welcome back to AI for Cybersecurity. Our next speaker is Erin Kubota. She is the Senior Counsel and Vice President at Wells Fargo. Please join me in welcoming Erin to our virtual stage.
Hi, I'm Erin Kubota. I'm a Senior Counsel and Vice President at Wells Fargo in the E-commerce, Innovation, and Technology Group. At Wells Fargo, I work on enterprise e-commerce and innovation projects and primarily support digital payments, authentication projects, online and mobile product development, fintech partnerships, marketing, and the related AI projects. Please note that even though I have experience working on projects involving privacy and cybersecurity issues, I am not a dedicated privacy or cybersecurity attorney at Wells Fargo. I also need to provide a disclaimer that I'm here speaking today as an individual and not as a representative or agent of my employer, Wells Fargo. So my topic today is on general AI risks from a legal and regulatory perspective. There are a number of legal and regulatory risks with using AI, particularly around data use. The legal landscape on AI issues is rapidly evolving, so it's a very exciting space to work in. There is a growing public interest and awareness of AI, as you probably all know. We see an increasing number of news articles about the different uses of AI and the potential privacy concerns with using AI, particularly with facial recognition technology. We are seeing growing interest from the federal regulators, such as the Federal Reserve or the Consumer Financial Protection Bureau, or CFPB, in the use of AI and machine learning. There have also been a number of recent lawsuits filed against tech companies for their development of AI tools. So there's a lot going on in the AI space, and you'll definitely want to consult with your attorneys on the legal and regulatory issues that arise from AI and machine learning usage. So in my session today, I'll try to highlight some of the legal and regulatory issues that you may want to think about a little bit further when building your AI models. So let's start with one of the fundamental questions, which is, can you use the data that you plan to build your AI models from? To answer this question, you may want to look at the related questions of, where is the data coming from? Who owns the data? Are you collecting the data yourself, or are you relying on a third-party vendor? So the data source for your models matters. You should look at whether or not your data is first-party data or third-party data. For example, first-party data could be your consumer data that you have collected or data that is in your existing databases. In contrast, third-party data could be data that you obtained from a third-party vendor. If you are using data from your existing databases, you should inquire where that data came from. Again, what were the specific sources for that data? Is it first-party data, your customer data? Is it third-party data, data from your vendor? Is there perhaps commingling of first-party data with third-party data, which potentially makes the analysis a little trickier? So why does this inquiry into your data's source matter? Well, a couple of reasons. First, there are privacy concerns that we'll touch upon in a little bit. Then there are also contractual concerns. If you have a contract with a third party, you probably need to do some due diligence and see whether your contract allows you to actually use the data in the manner in which you intend to, or whether your contract explicitly prohibits you from using the data in that way. Or are there other contractual limitations on data usage? In other words, there may be a provision that allows you to use the data for certain purposes, but not for other purposes. For example, you may need to review a contract, let's say the terms of use, to see if a social media site prohibits scraping of user images for potential use for facial recognition algorithms. The same analysis applies to first-party data. Does your contract with your customer, let's say there are terms and conditions that your customer agreed to, so does this contract allow you to use the data in the manner that you intend to? And even if there is a provision allowing for the usage of data, was that provision made clear to the customer? Or could that provision potentially later be challenged by the customer or a court? So if you are negotiating a contract with third-party vendors for AI use, you should ask them, where are they getting the data from that will be used for the models? And are the vendors obtaining domestic data or international data? Different privacy laws apply depending upon where in the world you are. Now, I don't want to get too deep into this area, but for example, the GDPR, General Data Protection Regulation, could apply if you deal with the personal data of individuals in the European Union. So you may want to make sure your contract with, say, a third-party vendor addresses that issue of international data usage. One thing to call out with the GDPR that is specific to AI is that it restricts the use of what's called automated decision-making, which is a decision made by using personal data solely on automated means, based on automated means, and without human intervention, and that has a legal or similarly significant effect on an individual. The GDPR also treats biometric data as sensitive data, which requires certain additional protections. So those are some examples of how international laws could apply to your project. It should also be noted that there could be legal issues if your database is stored at data centers that are located internationally. So even though domestic data may be utilized, there still could be international law privacy issues with moving the data in and out of a country. Other contractual concerns that you may want to keep in mind could include ways to potentially limit exposure to future claims and lawsuits. So you may want to negotiate certain provisions into your contracts, for example, clauses for indemnification or limitation of liability, to try to limit your liability exposure. You may also want to include express clauses in your contract on sharing and usage of data, including any limitations or permissions, and also for obtaining express consumer consent. Again, you'll want to think about the transparency in the way these contractual clauses are presented to the consumer. So going back to privacy, you'll probably want to evaluate the privacy concerns with data use for your models. Some of these privacy concerns include not honoring customer opt-out preferences for data use or not having permission to use the data from a consumer. So there are a number of privacy laws and regulations that could be relevant to your analysis, and these privacy laws are rapidly changing. You'll want to consult with your privacy attorney for a more thorough analysis depending upon your specific facts. But I'll try to touch upon some of the laws that may be relevant to your analysis. One law to consider is the Fair Credit Reporting Act. The inquiry under the Fair Credit Reporting Act is whether the data comes from a consumer report by a consumer reporting agency. Consumer reports are primarily used for assistance in determining a consumer's eligibility for credit. The report can include information that pertains to a person's creditworthiness, credit standing, credit capacity, character, general reputation, personal characteristics, or mode of living. If the data used for your model comes from a consumer report, then the issue is whether or not the information is used for a permissible purpose, for using that information as intended, in other words. Example of permissible purposes include underwrite purposes, employment purposes, and extensions of credit, to name a few. Another privacy law to take into consideration is the Gramm-Leach-Bliley Act, or GLBA. The GLBA governs financial institutions' treatment of non-public personal information about its consumers. It requires that customers be provided with certain privacy notices and the option to opt out of financial institutions disclosing their non-public personal information to third parties for marketing and other purposes. There are some exceptions that would allow financial institutions to share non-public personal information with third parties for certain purposes, such as fraud prevention or with the consumer's consent. Another privacy law that is important to consider is the California Consumer Privacy Act, also known as the CCPA, and the recently passed California Privacy Rights Act, or CPRA. The CPRA is a major expansion and amendment of the CCPA and establishes a new privacy protection agency in California and takes effect on January 1st, 2023. The CCPA applies to residents of California. It provides certain privacy rights to access, delete, and opt out of the sale of personal information by businesses that are subject to the law. The definition of personal information is very broad and includes information that identifies, relates to, describes, is reasonably capable of being associated with, or could reasonably be linked directly or indirectly with a particular consumer or household. Some examples of personal information include a person's name, address, IP address, email address, driver's license number, biometric information, browsing history, and geolocation data. It should be noted that the CPRA creates a new subcategory of personal information called sensitive personal information. Examples of that include one's social security number, financial account information, precise geolocation information, race, religion information, biometric information, contents of a consumer's mail or electronic communications. Under the CCPA, privacy notices may be required to be given to a consumer when collecting data. You may also need to care for consumer requests under the CCPA, such as requests to know about the personal information a business collects about a consumer and how it is used and shared. There are also requests to delete personal information and requests to opt out of the sale of personal information. In addition to California and the CCPA, other states may have their own privacy laws that you may need to be aware of. For example, some states have specific public records laws with limitations on usage of public records, while other states may not have those types of limitations on the same data set. Another example of a state law that may be of relevance to you is Illinois' Biometric Information Privacy Act. That law essentially prohibits the collection or capture of a person's biometric identifiers without first obtaining informed written consent. There recently have been some lawsuits filed under the statute against technology companies. The gist of the allegations in some of those lawsuits are that the tech companies violated the privacy rights of Illinois residents by capturing and storing their biometric identifiers without first obtaining their consent. Some of the concerns alleged in the complaints include the potential risk of identity theft, unwanted surveillance and tracking, and data breaches. Another relevant issue for privacy analysis may be whether the data that will be used in your models is anonymized or aggregated. So data that is truly anonymized may fall outside the scope of the privacy laws, which is why this is a relevant inquiry. But if you are presented with anonymized data, you should probably ask yourself, how are you getting to that conclusion? Is the data actually anonymized despite the label? So you may then want to do a deep dive and ask what the process is for anonymizing the data and really analyze how easy it is to potentially reverse engineer the data. Besides contractual and privacy issues, Another area to have awareness of is the potential fair lending type bias or discrimination concerns with your model. I want to note that the term fair lending is specific to lending or the unbiased treatment of customers when making credit-related decisions. However, the analysis under the fair lending laws can often be equally applied to evaluating AI models for potential bias. You may need to ask whether the model that you are working on includes inadvertent discriminatory biases based on protected characteristics. In other words, does the method of teaching the model good and bad outcomes inadvertently inject bias into the process? Fair lending protected characteristics include, for example, age, race, gender, and national origin. So if you are using biometric data, and also assuming there are no issues with the biometric data's usage, you may want to ask whether you training your algorithm with a diverse data set. In other words, do you have demographic variety? Some relevant federal laws on this topic of bias or discrimination include the Equal Credit Opportunity Act, the Fair Housing Act, and the Civil Rights Act. Certain factors that you might want to think about that might cause bias in the models are the algorithm's design, implicit human bias, or the data set that is being used. For example, is it too narrow in scope, or do you have a demographic variety? So you may want to consider conducting this due diligence to ensure that no use of protected characteristics or the like are used in the data inputs or in the model teaching. This may not be obvious, so you'll likely want to build in strong controls to evaluate that bias is not improperly being introduced in your models. For example, you may want to see that the algorithms are retrained regularly, that you introduce new training data, and that you are testing the outputs as ways to try to reduce bias. I do want to flag some related reputational concerns that may be relevant. One reputational concern could be the accuracy of the model. For example, there could be a negative reputational impact if an AI engine that is used for fraud detection does not work as planned and does not appropriately detect fraud by providing false positives. Another reputational concern is whether transparency is provided to the consumer. This has also been a hot topic in the news as of late. A lot of people would recommend that transparency be provided to the customer about their potential data use. And as discussed earlier, this potentially can be accomplished via contract, by providing clear disclosures to the consumer, and by obtaining express consent from the consumer regarding their data usage. Another reputational concern could be those privacy concerns discussed earlier. Some technologies may be more controversial to the public than others. And as I mentioned earlier, there could be applicable regulatory concerns with AI usage. There's growing interest by the regulators in the use of AI. For example, the CCPA noted in a July 2020 posting on their website that they are monitoring what's happening in the AI and machine learning space. Regulators are noticing that AI and machine learning are being used for fraud detection and prediction, identifying unusual transactions, monitoring and preventing cyber threats, among other things. So I think it's highly likely that we'll see more discussion from the regulators on these topics in the near future. So these are some of the legal and regulatory considerations to think about when working in the AI space. I thank you for your time and for the opportunity to share with you today. Thanks.
Thank you so much, Erin. The audience is giving you a huge virtual round of applause. We really appreciate you sharing these insights with us. All right, for the audience, it's time for you to make your way to your next session. Along the way, feel free to say hello to our sponsors, check your connection request, and do some virtual networking with your peers. Thanks so much, and we'll see you around.